Good morning, members. This is the meeting of the Bills Committee on Contracts, Rights of Third Parties Bill. This is our third meeting. We've already formed a quorum. Please invite the officials to come in first. Good morning. All four officials are from the Department of Justice today. First of all, after the public hearing last time, we proceeded to clause-by-clause scrutiny. At the public hearing, many deputations and individuals raised a number of issues to which the Department of Justice has responded. The paper is CB-4710/1314-01. I'll first of all ask Mr. Wong, the Deputy Solicitor General, to take us through the paper. Mr. Wong? Thank you, Mr. Chairman. First of all, at the last meeting, a number of deputations have spoken and we've responded to their remarks in paper 710/01. Let me add one point. After the meeting, we received further comments from certain deputations, including those from the Law Society. So, Mr. Chairman, if you so wish, we can supplement. Last time, deputations such as the CIC, Construction Industry Council, spoke. I'd like to defer to my colleague to respond to the remarks. Yes, and then later, Mr. Wong, you can explain the comments from the Law Society and the Hong Kong Association of Banks. Please give us a simple supplementary paper after the meeting on these further comments. Who will speak? Ms. Chang, yes. Thank you, Mr. Chairman. In the paper, our first response is to the remarks of the Construction Industry Council, the CIC. The CIC is in principle in support of the bill. Besides, the CIC considered that the construction industry would benefit from the bill. For example, there would be rights conferred on third parties by the bill, which would provide a more straightforward route to allow third parties to enforce their rights, to ensure that classes of third parties are protected and help avoid the formalities of execution of warranties and assignments and so forth. In respect of the comments of some stakeholders of the construction industry that the bill might create additional liabilities to contracting parties, the CIC is of the view that it would be sufficient to spell out who would be excluded. It's not necessary to set out in the bill expressly that contracts in the construction industry should be excluded. Our response is that we welcome the CIC's support for the bill. We also agree that the industry, whatever industry it is, so long as it is clearly expressed in a contract, the intention to permit a third party to enforce the contract, then it would not be necessary to set out who should be excluded from the bill. Our second response is to the remarks of the Hong Kong Confederation of Insurance Brokers, the HKCIB. Well, basically, they share the comments raised by the Hong Kong Federation of Insurers. They were also of the opinion that if an insurance contract would specify the applicability of the bill, it would make the position clearer. Later, we'll respond to the views of the Hong Kong Federation of Insurers. We'd also like to reiterate that so long as the parties to a contract stipulate clearly whether or not the bill will apply to that contract, the wishes of the parties concerned would be clear. So it is not necessary to set out the details in this regard in the bill. Our third response is to the remarks of the Chartered Institute of Arbitrators East Asia branch. We're also grateful for their support. They're in general in support of the bill, in particular Clause 12, which is about arbitration procedures. They also welcome the clarification in Clause 12 in relation to the third party's rights in arbitration agreements. Besides, the Institute also suggested some amendments in terms of wording, such that in 4.4, the test for accessibility, it should be defined under what circumstances the bill will not apply to the contract. And they put forth a suggestion on the amendment to that clause, that is, unless those terms are grossly unfair or unconscionable. The LLC did not spell out their recommendations on the applicability of Clause 4.4. So we'll leave it to the contracting parties to spell out their wishes. Besides, the Institute also suggests that under what circumstances should the benefit apply. They took reference from a certain English case. That is, we must explicitly clarify that the benefit refers to a direct benefit and not a consequential or incidental benefit. We also noted that English case, which is about direct benefits of third parties, not consequential or incidental benefit. Of course, we understand that this English case is of reference value in court. Instead of taking out a certain case to add it to the bill, a better solution is that when the court tries a particular case, the court can take reference to the prevailing case law. So it is not necessary for us to take out a certain case and add it to the bill now.
The fourth response is to the Life Underwriters Association of Hong Kong. In Clause 6.4, they have highlighted that it might not be practical. For example, if the third party is a minor, or if the promisee cannot be contacted, then it might lead to difficulties. They feel that Clause 6.4 might be difficult to implement. So we would like to respond to this because we are aware that the insurance industry had raised a similar issue. The parties, the insured and insurer, in the contract they have clauses stating under what circumstances should a third party be contacted, or the promisee would have to contact the third party. And in the clauses, if the third party is a minor, then both parties can take action. They can come to an arrangement in contacting the third party, the guardian of the third party, or as in the LRC report says, if they can't contact the third party, can they issue a newspaper notice? The LRC had considered this and proposed some solutions. The fifth response is related to the Chartered Institute of Building Hong Kong. Their opinion is that the constructors are rather passive, and it has to also depend on the government and main contractors' contracts, but they do welcome some clear guidelines where, according to this bill, third parties' interests can be protected. They also want to see some guidelines being promoted so that the public can have a better understanding. Our response is that we've taken note of their views regarding guidelines and promotional work. We understand that each case is different, and in general, the parties would have the best understanding of the contractual terms, and they could seek legal opinion on how to protect their rights. Now, the administration, in promoting this bill, we will promote the bill when it's enacted such that the public and stakeholders can have a better understanding of the contents of the bill, so the public can have a better understanding. The sixth response is related to the Hong Kong Construction Association. They feel that the bill is not necessary and it's not right, because they think that the industry, the construction industry, should not be included in this bill. If they are included in this bill, they think it brings about a lot of confusion and it would create chaos. And in the construction industry, they have collateral warranties and transferable guarantees that can protect third parties. They feel that that regime is effective, and they do not need the bill to provide more rights to third parties. They also believe that the construction contracts are very complex. It has different stakeholders and complexities. So if their contracts have to be examined again in light of our bill, they think it's timely and costly. Regarding the Construction Association, we want to highlight that when the Law Reform Commission drafted their report, they had considered in great depth the views of the Construction Association. In paragraphs 180 to 182, they have highlighted their views and responses. So the LRC feels that there isn't a strong argument to exclude construction contracts from this bill. The Construction Association feels that their collateral warranties and transferable guarantees can protect third parties. But I want to point out that these methods are complex and require a lot of time. We believe the bill has a more straightforward protection of third parties' rights. We don't need to rely on complex documents. Well, regarding the complexity of construction contracts, the industry needs more time to decide whether they need to upgrade their contracts to reflect the bill. We understand this, and we had stated on numerous occasions that the administration will give the industry time to see if they need to update their contracts. So we will give them sufficient time to review and update their contracts. So tentatively, we're thinking of giving them 6 months' time. If they have complex contracts, we welcome their views as well. We'd also like to highlight that the Construction Association, they want to exclude their contracts from the bill, but we want to reiterate that there is some help to the construction industry, whether it's contractors or staff. Their third-party rights can be protected. Moving on to the Consumer Council, they feel that there isn't any new legislation to protect consumer rights. Regarding the specific enforceability tests, the Consumer Council wishes that that could be relaxed. And regarding they want to relax the test where a third party may enforce a contract on which he justifiably and reasonably relies regardless of the interests of the parties, or a third party may enforce a contract which actually confers a benefit on him regardless of the purpose of the contract or the intention of the parties. They feel that this should have mandatory enforceability. We want to repeat that LRC had considered this in great depth, and in the report the LRC views had been expounded. So we want to repeat that the bill respects the intentions of the contractual parties. So if we want to safeguard the third party and ignore the third party's intentions, the Consumer Council suggestion says that even if the contractual party had not considered benefiting the third party and the third party benefits, that the LRC believes that is not its stance. So we should not adopt. They would not suggest adopting the Consumer Council views. Okay, thank you, Ms. Zhang. Let's discuss document number 01. Anybody else? Thank you, Chairman. This bill committee definition regarding the third party is very relaxed. So any party that is not part of the contractual party is a third party. Just now you mentioned the issue of interest. There were views related to the Construction Association, and the construction involves public interest, public housing, or infrastructure. So the third-party citizens, they might have an interest if a project is completed. There might be benefits to the public. So if there are some contractual problems related to the project, So aside from direct third-party interests, they're not parties to the contracts. They might be workers on the project. So ultimately, some people benefit from the project. So is the bill applicable to, so it's similar to the Consumer Council issue. Mr. Wong, when you respond, could you highlight the Dolphin Maritime decision? Because we would like to know what the principle of that case was. Just now, Mr. Low raised the issue of what is a third party and when would they benefit. I agree with Mr. Low. It's a very broad meaning, as long as they're not, it includes parties that are not parties of the contracts. If the consumers or staff, if they're not mentioned in a contract, they could be third parties. So the chairman said he asked for clarification regarding the case. The case dealt with direct or indirect interests. I can have my colleagues elaborate, but my understanding there was an indirect interest. And clause 4 states clearly that the third party has clear interest. So clause 4.1b, it gives a third party interest. So we see it might, for example, require the contractual parties deposit money in a third party account, while the third party might be able to deduct commission, but that is not a direct interest. So this is not included in the court definition of interest. Of course, in clause 4, it also emphasizes there has to be a designated beneficiary. Well, you said conferring benefit in 4.1b. You're saying that that clearly defines a direct beneficiary, because you're saying they use the term confer. So let's say you have a construction contract. It involves the residents' interest, but it doesn't include those people. But let's take an example of high-speed rail. So the shop owners might make a claim against MTR. So, but you're saying that they cannot, they are not classified as third parties, and they cannot make a claim regarding the MTR third party.
The pretext is that we have to reflect the intent of the contracting parties. If they would like to, through a third party, execute certain benefits, then they can do so, and that is stipulated in clause 4.1a. But if it is the situation of 4.1b, that is to confer a benefit on the third party, then clause 4.2 has a requirement. That is, the third party must be expressly identified in the contract by name as a member of a class or as answering a particular description. That is, not any person can casually execute the benefits, so you must combine 4.1a, b, and 4.2. Ms. Cheung? Dr. Low said that clause or the third party covers a lot of possibilities, but then according to the bill, the third party must be expressly defined in the contract. that is a particular person or a member of a class or a person answering a particular description. So it's not true that anybody can be defined as a third party. Sorry, Dr. Loh, I'd like to see whether other members have questions. Mr. Ronnie Tong. Mr. Chairman, I'm more concerned about housing estates. I note that in Clause 3, it is stipulated that the bill will not apply to land leases, particularly including the deed of mutual covenant in Cap 344. That means, given the design of housing estates, landlords and tenants cannot invoke provisions in the bill to protect their benefits and interests. They have to resort to other legal means. I'd like to know the policy considerations behind this. Why is it that the users of facilities and tenants cannot invoke the DMC? If this can be changed, those who use facilities in housing estates and tenants can be better protected. Mr. Wong, Mr. Chairman, at earlier meetings, we said that we referred to the opinion expressed by the Bar Association. Those views were clear. We had rounds of correspondence with them. Eventually, they agreed that for land leases and DMCs, they form an independent system of documents. For third-party benefits under the bill, if that is to be expanded to cover those circumstances, there may be uncertainties or inconsistencies. Of course, to judge that sort of scenarios, we have to look at land leases, as mentioned by the Bar Association, because for land matters, we have a systematic interpretation system for those circumstances. So Clause 3.2 of the bill is involved, including the instruments, promissory notes, sea transport, air transport arrangement agreements, and so forth. As for DMCs, the Bar's view is that indeed in DMCs there are different provisions, some related to land leases, which can be executed through DMCs. But for those beyond that realm, to differentiate between those within land leases and those without is rather difficult. So in our paper on CSAs, we propose to exclude both categories, that is, land leases as well as DMCs. For DMCs, the definition used is under the Building Management Ordinance. I'll see whether Ms. Cheung has anything to supplement. Mr. Chairman, I don't think that's an answer. Well, they said that land leases form a different system. That's very obvious. So I would like to know why the benefits of users of facilities and tenants of housing estates are not covered. DMCs are contracts as well. They're different from land leases, in particular in terms of the use of common facilities, how to handle matters within a particular unit, obligations, and so forth. Well, if you just listen to the Bar Association, you won't be able to address the concerns of society. So I'd like the administration to think about this clearly. For DMCs in relation to common areas, common facilities, building safety, users' benefits as well, and so forth, I believe the bill should be expanded to cover that area. Ms. Cheung, a brief response, please. I'd like to briefly explain why we've recommended this in the bill. For DMCs, for the landlords, the small landlords? Well, basically, the major landlords are the land developers, so we're mainly talking about third parties and the small landlords. Very often third parties, or perhaps I can say this, in DMCs, a third party can sue a third party. That is, a small landlord can, in relation to a DMC, sue another small landowner. Sorry, small landlords are not third parties. I'm talking about those without a land title. Take, for example, you go into a facility, say if you are a guest or if you're a tenant. Well, these people do not have titles to the building because they're just tenants. They cannot invoke DMC provisions to complain against the owners' corporation or individual landlords of individual flats. Well, small landlords can invoke the DMC, so they're not within my question. Well, Mr. Ronnie Tong, perhaps we can ask them for a written reply. Yes, we would like to know the concepts they've considered before they exclude tenants and users of facilities. Well, Ms. Chang, please give Mr. Tong a written reply. Dr. Lo Wai Kwok, 4 minutes again. Mr. Chairman, in the first round, my question attracted a response from the administration, so I'd like to ask whether the definition on third party can be further clarified, because that's a very broad definition. For an ordinary citizen, he will believe that third party is a very broad term, and for many public works projects, a citizen can say that in accordance with the bill, I'm a third party, because as a result of failure of execution or contractual changes, I'm affected, so I can invoke the bill. But in fact, that's not the case. If I'm a layman, I can argue with you because the definition is so broad. The ensuing clauses make it very clear under what circumstances you can put up a claim. Would you consider clarifying the definition for third party? Well, maybe this is a textual issue. In 4.1, A and B is quite clear. Well, if that is the case, why don't you clarify the definition in Clause 3? Well, last time we explained that to a certain extent we took reference from the relevant laws in the UK in the definition. In fact, the concepts are the same. That is, the third party is not a contracting party. Dr. Lo Wai Kwok is worried that ordinary citizens may not fully understand the bill in terms of third party, so publicity is important. The public should understand that Clause 4 is the crux of the whole bill, and they should study the details therein. That is, the contracting party's intent is crucial. It must be specified that a third party through Clause 4, 1 and 2 must satisfy the requirements in the bill. Mr. Chairman, for the promisor and promisee, in your definition, you mentioned Clause 4. So I can see that you would like to make the definition clear. That is, what's a promisor, what's a promisee. If that is the case, why can't you clarify the definition in Clause 3? Mr. Wong, perhaps you should go back and see how you should answer that question. Or maybe you have an answer now. Well, Mr. Chairman, Clause 3 reflects the concept behind the law of contract. If a certain party is not a contracting party, then he is a third party. Well, Dr. Low is asking, if he is a third party, can he very easily invoke the provisions in the bill? Then we should go to Clause 4. Oh, you don't need to explain again. I understand. My question is, why can't you elaborate your definition in Clause 3 so as to avoid the so-called beautiful misunderstanding I mentioned just now. Well, Dr. Low, under the common law, the definition is very clear. If you're not a contracting party, you're a third party. Now, in this bill, can you link that up with Clause 4? Can you just add a sentence? We are not altering the concept of contracting parties. If you cannot answer the question of Dr. Low now, please go back and think about it. Okay, we can go back and think about it. Yes, think about it. The definition in Clause 3 will affect all provisions in the bill, like Clause 7, Clause 5, and Clause 6, which is about the power of the court, the remedy available, and the rescission and variation of contract. So we'll go back to study that. That will affect the whole bill. Mr. Ronnie Tong, should we specially consider third party to contracts? Take, for example, a chain contract. A chain contract, like a supply contract. For example, you're a wholesaler, you sell commodities to a retailer, and then the retailer can sell the commodities to other parties. Chain contracts. Strictly speaking, any non-contracting party is a third party. So I'm asking about chain contracts. The provisions therein may be in conflict with the head contract. Under the definition here, a person who has signed the second tier of contract will be a third party to the first tier of contract. That is the head contract. Then he can invoke this bill to benefit from those benefits that he originally does not enjoy. Then he can invoke the bill to claim benefits under the head contracts, instead of honoring his contractual benefits under the second tier of contracts. Have you considered this scenario, which is quite common? It's not just in terms of commodity sale. For contracts in relation to facilities and their users, for example, in the construction industry, you have the main contractor, subcontractors, subcontractors, and so forth. So I'd like to know the position of the government in this regard. Is the bill too lenient? I won't like to use the term, but I'm concerned that certain parties may be able to use loopholes in the bill. Well, I understand Mr. Ronnie Tong's point. On the one hand, a person can enjoy his benefits under the contract to which he is a contracting party. At the same time, he may also benefit from the head contracts. Well, we refer to the UK laws. Well, after the enactment of the bill, we can handle the benefits of the third parties in such scenarios.
It doesn't affect their original rights. Of course, in chain contracts, the manufacturer to the supplier and supplier to the consumer, and the consumer, if they become a third party between the manufacturer and the supplier, and if the manufacturer and supplier agree to give the consumer extra benefits, then that is admissible. It doesn't rule out the possibility of the consumer suing the manufacturer. But there is a safeguard where they can't get double benefits. And there is also ruling out of double liability. Will there be overlapping liability regarding the consumer and with the supplier between the manufacturer. So if the supplier, the promisor, and the promisee, that is the manufacturer and the supplier, if they state that there's no defect in the product, but when a problem arises, they can only claim one compensation. They cannot receive double compensation. So we hope that through Clause 5, they have that option, they have that right, but it has to be fair and equitable. I understand there cannot be double compensation. That is correct. But I want to say that a larger interest, it might not be double benefit, that is amongst the two, if they can choose the interest in the first level of contract might be larger than the second level or third level of contracts, and therefore you are encouraging them to not follow their original contractual sequences and leapfrog to the first level of contracts, because that interest might be larger. So they might make more, they might launch more claims at the first level of contracts. I understand they cannot receive double compensation, but shouldn't there also be stipulation that they cannot receive compensation greater than their level of compensation? Let me use an example. You have different levels of subcontractors. In the first subcontractor, the remuneration might be larger, but at the third subcontractor, the remuneration is lower. So let's say if all of them breach contracts, let's say they sue their own contractor, they only get $10, but if they sue the main subcontractor, do they still only receive $10 compensation? Or would they receive compensation greater than what their contract stated? But if both parties, if they excluded third-party rights, then in the chain contract, theoretically, they only rely on the second level of contracts. If they had foreseen that and they excluded third-party rights, so could Mr. Wong comment on that? I agree with the chairman. It depends on the contractual arrangements. If the first level of contracts really want to give third-party benefits, it just reflects the contractual intentions. We feel that is reasonable. Of course, it has to depend on the circumstances. So, as the chairman said, at the first level, they might have already ruled out that. They might have said that this is just an arrangement between two parties, and they might ultimately have to rely on the second level, third level contracts. But the spirit is that is to reflect the intentions in the first level contracts. So this is just a matter of convenience. They can also choose to exclude this option. Chairman, I understand. This will affect commercial culture. You can say that you just need to look after your own interests. But as a piece of legislation, if a person doesn't understand the law, they can't afford a lawyer, will that be not fair to him? You're just saying that you have to look out for your own interests? Well, this attitude is not quite appropriate at the legislative stage. Chairman, I can add that our attitude is not to allow the contractual parties to handle it. The intention is that they have a contractual freedom. If they have confirmed the arrangements, we also want to avoid double compensation. So Mr. Tong example, if they really want to confer extra benefits, let's say in the first contract they want to give $20, and in the second level contract they can only give $10, and if they really do want to confer $20 to a third party, we don't see why the third party cannot enjoy their rights according to the first level of contracts. So clause 5.4 wants to state that they will not avoid their other rights outside of the contract. So through third-party rights, if they can get extra benefits, let's say a difference of $10, they can make that claim. That is the legislative intent. They cannot. We're saying they cannot claim double benefits at the first level and at the second level. Any other questions regarding deputations' responses? So if you have two chain contracts, the whole legislative intention is to protect third-party consumers. So if you want to have a provision limiting the damages, when the court assesses the damages, whether it's a consumer or subcontractor in the second level contracts, you're a barrister, I'm not. So when the court rules on whether they should make a claim according to the third-party rights or their contract, it would depend on how much the claimant has suffered to determine the amount. So this might be something I need to raise when we reach clause-by-clause scrutiny. We're not talking about policy. When we move into clause-by-clause scrutiny, we'll deal with the clauses. Regarding the court's rights, it's also very general. But you should have some principal guidelines. We might have contradictory principles. In the example just now, in the first level of contracts, you are limiting the subsequential contracts. For example, the head contract had stated that how much the ultimate beneficiary would receive. It has restricted the free contracts. I might not be correct, but since there is such a problem, we need to deal with it squarely. We need to justify the policy. We need to have a stance and an attitude. Mr. Wong, so perhaps you need to outline your policy. Otherwise, Mr. Tong would put forward some CSAs. Any other questions? If not, we move on to the second item. Some other deputations have have put forward some suggestions. Professor Lee Mason, the Association of Banks, you have not provided a written response. Could you highlight your response and their views? Their suggestions are related to the bill. I can provide an initial response. For example, the Law Society in October 2010, they had some suggestions in different clauses. Well, we have considered that. We have decided that it might be hard. For example, in 3.1, it deals with contracts that come into effect after this bill is enacted. If previous contracts had to be amended, then how would that be dealt with? Well, there might be different situations. There might be just minor wording amendments, or there could be major amendments. But we need to clarify that they want this bill to be applicable. Well, we have a consensus with the Law Society. If it's clear, we can deal with it. We have minor amendments or major amendments. We don't see where other jurisdictions, when they apply the third-party rights, they will use complex. They use a complex way of handling it. Well, we feel it's better to have the contractual parties deal with it. So the Law Society, in Clause 3.1, that was their opinion. Regarding Clause 6, we've made some textual amendments, and we see that whether we want to use the UK wording, but internally in our discussions with our colleagues, we've made some appropriate amendments. So when we get to clause-by-clause scrutiny, you can decide whether the wording is appropriate. For example, 6.1, the Law Society said whether we should use the UK wording. And in 6.2, there is some change in wording. We have mentioned assent, and we included the relevant notice being awarded. So we feel that our policy intention has been achieved. And in the original Clause 6, there was a suggestion that regarding a party, the UK uses the parties, but they don't have major contention on this. Regarding Clause 6, regarding subsection 3, they wanted to make reference to the New Zealand legislation.
After reading the LRC report's recommendations, we saw that the testing criteria in New Zealand are different from ours. Material altered is the expression in relation to Clause 6 all the way up to page 4 about the concept. But for us, we don't have that element. We're more similar to the UK situation. There are basically two scenarios. First of all, if the third party agrees to the provision, or there's no material reliance on the provision. That is, the original interpretation is related to the original interest under the contract. Then the relevant mechanisms in the contract can be triggered to protect the third-party interest. The LRC does not want to adopt the New Zealand situation. It recommends the UK situation. As for Clause 7, the Law Society mentioned leniency in the court. That is, without the consent of the third party, the court can exempt consent from the third party to be obtained. The Law Society agrees to that legal direction, that is, to adopt a more lenient approach. As for Clause 10, in relation to double interests or benefits, I think the major difference is whether or not we should stipulate clearly what we want to do to protect the promisor in relation to double benefits. The Law Society would like, or we would like to clarify the situation, while the Law Society does not consider it really essential to expressly say this in the bill. We refer to the LRC recommendations. And for Clause 10, they also asked about a single party or dual party consent. They mention relevant legal provisions. We would not like to affect the existing avenues for pursuit of claims, so we refer them to clauses 5 and 6. And then their clause 11 is actually our clause 12 in relation to arbitration agreements. For exclusive jurisdiction clause and arbitration, that is what is in clause 13, they asked whether mediation should be considered. For arbitration agreements, it is essential to have specific provisions in the clause because we have to consider Cap 609 and its relation to this bill. If a certain person is not an arbitration party, he cannot make use of the arbitration mechanism. So Clause 12 of the bill is essential. At the same time, we agree that for Clause 13, exclusive jurisdiction clause, it's not essential to put it here. It's just like mediation. It's not necessary or essential to put it here because Clause 4.4 of the bill already expressly stipulate that in the execution of the provisions, there are certain prerequisites that have to be met, be it arbitration or exclusive jurisdiction. These provisions have to be observed. We believe Clause 4.4 has already set out the basic principles. At the same time, we respect the recommendations of the LRC. That is, the exclusive jurisdiction clause should be included in the bill. So we put it here. But strictly speaking, we don't think that's really essential. When it comes to mediation, we only need to resort to the broad principle of Clause 4.4. There are other provisions to resolve disputes. So if we are to put in other clauses, many other clauses may be included in the bill, but they are not really essential. That's about the Law Society's views. Would you like to go to the Hong Kong Association of Banks' views as well? Well, if we have too many issues to discuss, it won't be good. All right, Mr. James, so you ask your questions first. After the enactment of the bill, it will only apply to those contracts signed after the enactment of the bill. For those contracts signed before the commencement of the bill, say if one of these contracts is to be modified, what you told us was that in other jurisdictions they don't give special treatment to this scenario. So, what's in your mind? If there are to be amendments, then those amendments must be related to the third-party interest, right? Yes or no? If a third party has the right to sue, then it is already established that it is agreed that a third party can take legal action. So whether or not the bill takes effect doesn't matter, because a third party does have a chance to sue. Well, if that's not the case, I'd like to know the situation in other jurisdictions. Do you have any precedents on third-party claims and third parties' right to take legal action? So we would like to know where the line is drawn and whether or not our approach here is more or less correct. Well, perhaps I should stop here for the moment. Mr. Wong, as for the situation mentioned by Mr. James To, we did not detect any precedent. After the commencement of the bill, if the contracting parties would like to give a third party a right, then a supplementary contract can be signed with new benefits and interests. Interests and benefits can be excluded as well. Amendments can vary in nature, so it should be expressly spelled out in the contract. Say if the purchasing price is $1 million in the original contract for the third party, after the commencement of the bill, the contract is amended to change that to $1.2 million. So it's only a change in the figure. So the question is, just by changing the figure, can a third party execute the interest? Because under the common law, the amendments are made after the commencement of the bill. So $1.2 million is the new figure and the third party may benefit. Well, I of course understand what you are saying. For certain jurisdictions, as you mentioned, they have not handled such a scenario. So it depends on the future court rulings then. Have you made any assumption in this regard for any contract, if the contract terms are to be changed afterwards, unless it is expressly stipulated that a third party may enjoy a new interest? Are you inclined to require that such a term be included in the first contract? Otherwise, can you explain to us how we're going to handle such uncertainties? For the very certain scenarios, you don't need to think about it. But very often, we have to resolve those unforeseeable scenarios. Do you have any policy inclination in this regard? Mr. Wong, I'd like to thank Mr. To for his question. Policy-wise, after the commencement of a bill, if a contract is still effective, and this scenario emerges only after the commencement of the bill, then it will be subject to this contract's rights of third parties bill. Say, after the 1st of January 2015, there's this contract, which can be a brand new contract or a contract to amend or modify the first contract. Anyway, this new contract can make use of this bill to execute certain interests. Mr. James To, I think you are talking about contracts concluded before the commencement of this bill. We'll say Party A and Party B agreed to this $1 million before the commencement of the bill, but that involves the interest of Party C. After the 1st of January 2015, the figure is changed to $1.2 million. Are you inclined, policy-wise, to require that unless the contract gives Party C a very clear interest, Party C does not have any interest, so you rely on the original contract. For the amendment contract signed after the 1st of January 2015, are you inclined to require that contract, supplementary contract or new contract, to stipulate that Party C enjoys the interest? Mr. Wong, policy-wise, we agree with Mr. To, because the supplementary contract takes effect after the commencement of this bill. Although it involves a minor amendment only, that is $1.2 million instead of $1 million, the third party enjoys this interest of $1.2 million, so it should be covered by this bill. So the bill will take effect, will apply to that latter contract. Well, let me follow up. My assumption is that in the original contract, for example, both parties know the UK practice on third-party interests or rights. But that's not in the original contract. Later, they changed the amount from $1 million to $1.2 million. So how are you going to weigh these two different scenarios? So in principle, how would you view this? If in the first contract, the third-party contract is excluded because they know in advance the UK practice, and then they sign another contract later after the commencement of the bill to change the figure. Mr. Chairman, if at the beginning they would like to rule out third-party rights, then even after the signing of the second contract, we should consider the first contract as well. So it's safer to include the same provision in the second contract, which is to amend the first contract. But the first contract already excludes the third-party rights. So maybe in the second contract, the third-party rights are also excluded. What about other members? Would you like to ask questions about the views of the Law Society? If not, Mr. Wong, can you go to the next two? Well, Mr. Chairman, I'd like to ask another question. I don't know whether it's about the Law Society's views. Mr. To, if it is about other views, please queue up again. We have plenty of time. I'd like them to go to Professor Lee Mason's views and the Association of Banks' views. In the letter dated the 14th of May, Professor Lee Mason is talking about certain comments which were previously expressed by him. That's about the exemption clause, whether there should be a reasonable test. Last time we said that we considered the views of the LRC, that is, we should not exclude the relevant provisions. That is, the exemption clause should be subject to the question of whether or not it is a reasonable stipulation. So we agree with the LRC. That is the proper handling method. As for due obligation, Professor Mason mentioned Clause 11. He recommended recovered by the promisee in relation to Clause 11.4. On this, we consulted our colleagues in the drafting division. We had some discussions. Clause 11.3, it's about double liability, and it's also related to the sum involved. We should clearly understand it together with Clause 4. They're talking about the same issue on double liability.
So the current wording is sufficient to handle this. We have considered in detail Hong Kong U's view, and the drafting measure is the simpler the better. So when there's ambiguity, we might need a clearer definition. But in Clause 11, it's only mentioned once, and In Clause 4, we have made it clear, so it doesn't need to be repeated. And in Clause 11, Professor Mason also mentioned other issues, personal loss, and the promisor and promisee, whether they have extra personal loss. Well, we want to emphasize that if the promisee has got compensation in 11.3 from the promisor, then there is some responsibility there. But if the third party has extra loss, or if the promisee has extra loss, compensation is not ruled out. So we see the current legislation is sufficient to deal with that. There's also mention of Clause 11.4 is duty to account, and that needs to be handed back to the third party. Professor Mason had quoted the LRC report where it's more appropriate to be dealt with by the court, and we maintain the report's stance, that is, allow the courts to deal with it. Regarding arbitration agreements, we are aware that Professor Mason, his concern is whether there is a burden versus a conditional arrangement, because the whole spirit is just giving the rights to the third party, so the liability cannot achieve that effect. But previously we discussed Clause 4.4. If there are some conditional benefits, that is what that is also the LRC's understanding. So we're not handing the legal liability to the third party, but there are conditional benefits. So we need to comply with the conditional requirements, and arbitration is one of them. But the condition is that there has to be an arbitration case. And then it's mentioned mediation, and we already answered that in our response to the Law Society question. But Clause 4.4 should be able to handle that. Regarding Clause 13, exclusive jurisdiction clause, our understanding is it's not a burden. The third party also needs to comply, and whether we need further supplement, we feel that Clause 13 is sufficient. So when we deal with the Association of Banks, I'll have further supplement when we talk about the non-exclusive jurisdiction clause. Professor Mason we have observed that the UK and other jurisdictions development, we have looked at that. We feel we hope that we have considered the LRC report and also meet current needs. So this is my response. And we're referring to paper CB bracket 4672/131401. Will we have a written response? The relevant questions and responses even though you've given us a verbal response. Well, we have a few meetings going on, and legislators are shuttling in and out of different meetings, so we would need a written response. Yes, we'll provide a brief response in writing later. So let's deal with the Association of Banks, CB 4698 1314-01. Mr. Wong, regarding the letter on 21st of May from Association of Banks, these are their views during consultation. They asked for sufficient time to amend their standard terms of contracts. Yes, we now suggest about 6 months, even after enactment of the bill, 6 months before it takes effect. Regarding Clause 32A, will we include checks, a bill of exchange? The definition is sufficient to include a check, and the drawee is a bank, so we feel this definition is sufficient. Clause 3.5, regarding the definition of negotiable instrument, we have a definition at the end, and it includes any instrument embodying a monetary obligation and transferable by delivery or by delivery and endorsement, whether or not the instrument is capable of being transferred free from equities. So we hope that this definition can reflect the intention. So, negotiable instrument, we just want to reflect the common law definition. But I'm not sure. Could my colleagues elaborate? We had considered that we have a very clear definition in common law regarding negotiable instrument. So even in common law, there's a narrow or wide definition. But we'll always look at, the LRC will look at the wider definition. So we've included the LRC concept. Moving on to clause 5.4. We have two important bills committees convening. In the next room, dealing with election miscellaneous amendments. We are now dealing with a letter from the Association of Banks on 21st of May, CB 4698 1314-01. The government doesn't have a written response. The letter was issued on 21st of May, and now they are responding point by point. And my understanding is that you will provide a written response. Correct. Mr. Wong, please continue with. We'll provide a more detailed response in writing. But we're now dealing with clause 5.4, and it will not affect existing rights regarding the contractual parties. There is available to a third party who enforces the term of a contract under Section 4 a remedy that would have been available to the third party. Regarding rescission and variation of contract, we have made some amendments. We have communication of assent. The promisor has noticed. The promisor has received notice of the assent. The promisor has received this notice of assent. So the intention is that the promisor is now aware, and it can comply with the need of crystallization. So they cannot make any arbitrary amendments. Regarding clause 6.4, the Association of Banks, they seem to want to repeal this, but we have made reference to LRC. We want to deal with it in two ways. This has to be viewed in tandem with 6.3, where it says, where it states the arrangement. It would amend 6.1 and 2. So in order to protect the third party, there are two choices. The third party is aware of the term referred to in subsection 3, or one or more parties to the contract have taken reasonable steps to make the third party aware. We agree with that. And moving on to 7.3, the courts the other party or each other party to the contract agrees to resign or vary the contract. We think that we need a more relaxed, and in the UK it's a bit more narrow. And this is the situation as mentioned by the Association of Banks. We feel a more relaxed approach, and the LRC approach is more appropriate. Clause 11.3 and 4. These deal with double liability. We want to emphasize that it should not affect their claim, but the promisor will have double liability. We want to be fair and clear. In clause 12 and 13, in clause 9, it refers to clauses, in paragraph 9 it refers to clauses 12 and 13. These are arbitration agreements and exclusive jurisdiction clauses, and whether it will affect a third party. As I mentioned just now, the intention is to be understood as a right, but with a condition. Then according to clause 4.4, the third party should comply with this requirement. Regarding paragraph 10, the exclusive jurisdiction, should non-exclusive jurisdiction clauses also be handled?
The nature is similar to mediation. It's not essential to put it here because you can use the broad principle in clause 4.4. But then in clause 13, we've added this exclusive jurisdiction clause because we respect the views of the LRC. That is, there should be a specific clause in this bill. But our view is that it is not essential to put it in the bill. So we put in this clause 13 exclusive jurisdiction clause. As for the other controversial scenarios, we should resort to clause 4.4. That is the specific principles for other disputes. So we can resolve the disputes through clause 4.4. Thank you, Mr. Wong. For this letter from the HCAP dated the 21st of May, we haven't got a written reply from the administration yet. I'll give members 1 to 2 minutes to go through the HCAP's letter to see whether or not they have any questions. Otherwise, we'll await a written reply from the administration, and if necessary, we can discuss again next time. So just spend a minute on the letter. Members, perhaps we'll go about it like this. We'll await a written reply from the administration, and then I'll set aside some time for discussing the written responses by the administration. Well, we've received some CSAs as paper CB bracket 4710/1314 bracket 02. We've got some not so complicated CSAs. Mr. Wong, would you please take us through the CSAs? We've proposed 2 categories of CSAs, some related to Clause 3.2, covering 2 scenarios in relation to land leases. That is the Clause 3.2b in the bill. But then, in terms of wording, there may be an ambiguity. That is, now the covenant is restricted to the DMC as defined in the BMO. The Bar Association says that sometimes it is difficult to differentiate between a land-related or non-land-related covenant, as DMCs are under a systematic regime already. Then with this new system, the existing draft of the bill may not be ideal, so we would like to have a CSA to exclude all DMCs. As for Clause 8.2, we propose that the word "that" be deleted. That will not affect the content of the provision. It's just a drafting issue. Mr. Chan, do you have anything to add? Well, why do we propose the addition of the word? Is because in the preceding paragraph there's no "that." So for this particular clause, we would like to delete the word "that" as well. Mr. Wong, for clause 3 bracket 2, you would like to add a subsection bracket BA. For 3.2b, you delete a covenant relating to land including. So a deed of mutual covenant as defined by section 2. So you would like to add BA between B and C. You would like to add a covenant relating to land to make it clearer. Yes, Mr. Chairman. So for these amendments, members, do you have any questions? Otherwise, we can discuss them when we proceed to clause-by-clause scrutiny. All right, so much for these papers. I'd like to resume clause-by-clause scrutiny. Last time, we just completed clause 4. I think our legal advisor has certain comments on Clause 4. Legal advisor, yes, Mr. Chairman, for Clause 4 there are two aspects. First about policy, and then for Clause 4.3, I have a question about the Chinese draft. For the first issue, the Chairman and Mr. Alan Leung asked about the policy intent. So I'd like the administration to further clarify the matters as to allay members' worries. That's in relation to Clause 4.1 and Clause 4.3 and their operations. And at the meeting before the last, we mentioned two scenarios. A, the contract expressly provides that the third party can execute the term, can enforce the term. B is more indirect. That is, the term purports to confer benefit on the third party under certain circumstances. Say if parties A and B sign a contract for party C to carry out certain construction works. So that falls into B. So two scenarios for the government to clarify. For scenario A, that is, the contract expressly provides that the third party can enforce the term. In the same contract, maybe towards the end, or in a standard contract where there are standard provisions to the effect that a third party cannot enforce the contract. That is, inconsistent terms in law. Well, if that is to happen, what is the policy position of the government? In that sort of scenario, how should we go about it? That is A. Chairman, as for B, that is, the term purports to confer benefit on the third party. As I said, if coincidentally in the same contract towards the end, there are certain terms that expressly stipulate that a third party cannot enforce the contract, or the bill does not apply to that contract. Can the government clarify? Under the framework of the bill, such scenarios can happen. That is, the contracting parties can include such terms in their contract. If these scenarios are to occur, what is the policy intent of the government in the handling of the scenarios? Then I can move on to the Chinese draft. Thank you. Mr. Wong, you've heard the question. For Clause 4.1a, position is 4.36 of the LRC report. That is, if the contract expressly provides that the third party can enforce a contract, or otherwise, the court can invoke that provision. But if the third party cannot enforce the contract, it depends on the interpretation of the court of the contract terms. It's quite unlikely that the court can override an express term in the contract on whether or not the third party can enforce the contract. In 4.3, Clause 4.1b is mentioned. For Clause 4.1b, yes, a third party has a certain right which can be expressly included in the contract in terms of language. Professor Trito did comment in his book on law of contract that the exclusion of certain scenarios might not suffice. So we considered how the bill should be drafted. Of course, the contract should be clear in excluding a third party expressly. But sometimes that may not be sufficient to exclude the effect of 4.1b. It really we really have to look at the actual scenario and the contract terms. And the practice of business law may also be relevant. So that's our policy intent in relation to Clause 4.1 and Clause 4.3. Legal advisor? Chairman, then I'd like to mention something about the Chinese draft. That is about 4.3 of the Chinese version. It seems that Clause 4.3 of the Chinese version can be further clarified. At the moment, the Chinese reads, 如按經恰當解釋的有關合約可由上述第三者強制執行有關條款，並非立約用意，則第1B 款不適用。Mr. Chairman, if you just look at the Chinese version, it's rather difficult to understand. If you look at the English version, it's clearer. Well, usually it's the case. For all bills, that seems to be the case. Well, yes, Mr. Chairman. So we noted the difficulty in interpretation of the Chinese version because the passive voice is used in the Chinese version for the two short sentences in the middle of that clause. So we have a specific recommendation. We'd like to see whether the drafting division can consider swapping the two commas to change the passive voice to an active voice. That is, 如按經合作解釋的有關合約，並非由上述第三者強制執行有關條款. So by changing that to an active voice, the Chinese draft may be easier to understand. Any immediate response from the administration? Mr. Chan? In our discussion with your Legal Services Division, we received that proposal from your legal advisor. We're grateful for his advice. However, that may change the degree of significance of the two aspects, because usually you put the more important first. Well, enforceable by the third party is more important than proper construction of the contract in relation to the significance of those two aspects. So the significant aspect is the term is not intended to be enforceable by the third party, instead of on a proper construction of the contract. Members, or Mr. Alan Low, do you have any comments? It is difficult to argue with the experts. I agree with the legal advisor. If you read the Chinese text, it doesn't work. Well, I don't quite understand the administration's point about which should come first. Now, the English version is clear. It's for the court to determine a proper construction of the contract. And the construction is that the third party should not benefit. Then subsection 1B does not apply. So long as you can express that meaning, it will be all right. Now, the Chinese version is 如按經恰當解釋的有關合約，可由上述第三者強制執行有關條款，並非立約用意。
咩讀多兩次都可能明嘅。
Well, you might understand it after repeated reading. The Chinese wording, we need to reconsider the the wording order. I need to state directly the drafting standard needs to be enhanced. I've stated that more than once. It's not a technical word-by-word translation. You have to consider the user, whether they can understand the meaning. Well, let's move on to Clause 5. My practice is to go through Chinese and English. Mr. Wong? Thank you, Chairman. Clause 5 is remedy available to third party. We want to express that the third party can act like a party of the contract and seek remedy for any breach. So we have 5.1.2.3. 5.4 says that it will not affect a right or remedy of a third party that exists or is available apart from this ordinance. That is the content of Clause 5. Hang on. Clause 6. Rescission and variation of contract. In Clause 6, in 6.1 and 6.2, if a third party, they can enforce a contract, the parties may not amend it easily. They need agreement from the third party. In 6.1, that has been expressed, including rescinding or varying the contract. Well, when will this constraint appear? It's when the third party agrees, and this agreement has been issued through a notice. The promisor needs to be notified. That's 6.2a. The second possibility is the third party has relied on the term, and there are also two conditions. The promisor is aware of the reliance, or the promisor can reasonably be expected to have foreseen that the third party would rely on the term. So 1 and 2 have highlighted the principles. In 6.3, there is a condition that allows for not relying on the first constraint. In 6.3a, one or more parties to the contract may rescind or vary the contract without the third party's consent. Situation B, certain conditions need to be met, and it might amend the principle in Clause 6. We think that a time limit, within this time limit, the let's say 3 months after the time limit, then they might not need to comply with that. But there's also a condition here in 6.4. The third party is aware of the term referred to in subsection 3, or one or more parties to the contract have taken reasonable steps to make the third party aware of the term. So Clause 6 has listed the two conditions. 6.1 and 2, 6.3 and 4 allows other terms for rescission and variation. Well, I have a question. If you look at 6.2a,
嗱，assent 只不過話佢知悉亦都同意嗰個合約啦，係咪？即係
So they have assented. If you look at 6.1a, if the parties to the contract agree to a third-party right, but they are aware of this term, what is the policy intention? Why can't they rescind? There's no cost incurred. They're just aware of the existence of this contract. Do they still require the third-party agreement to rescind? We're talking about rescission. Well, if you look at it this way, 6.1 says they cannot rescind the contract without the notice of the third party, but the third party has agreed to that term. So you can imagine that if the third party, if they were not aware of this term, if this was a confidential contract, they did not know the existence of this, they could not agree with that. Or in 2b, the third party had to rely on that term, so they need to be aware of the existence of the term. So if both parties want to confer a right to the third party, they might notify them. But if they choose not to notify, then the third party is not aware of that. So they cannot activate the clause 6.2. This is quite important. So as Mr. Wong said, A and B draft a contract and C might benefit, but C was never made aware that A and B had made this contract and locked it in a closet. So 6 is not applicable. Am I correct? The C is not made aware. But if he's made aware later, and as long as he is aware, and as long as the contract and as long as before it is amended, he's made aware, then C, well, C does not know that A and B have exercised the contract, but after exercising the contract, the third party might not be aware. So, do they still have rights under clause 6? Can they still vary or rescind the contract? Well, you can imagine that if both parties can exercise the contract and they want to confer the third party a benefit, then theoretically they have achieved the purpose. But let's say there were some breaches of contract, then the third party has to see if clause 6.2 was the conditions in clause 6.2 were met. So we have a contract. There are different rights. A and B conferred party C a benefit, but the third party wasn't aware. So A and B have exercised the contract, but one day, let's say phase 3, phase 4 of a construction project needs to be amended, but the third party was not aware. They could still vary the contract. Is that correct? My understanding is yes. 6.2a is that they have to, the third party has to agree. Another possibility is they have to rely on that. But if they never were aware, then they couldn't rely. I want to understand this. The assent, is it a direct expression, or is it imputed knowledge of a third party? So, was it actual assent? Was it imputed knowledge? Well, the policy is that we require notice. This could be verbal or written, or by other means where the third party is notified that the third party has to have this notice. So one of the two parties has to notify. But what about assent? So notice, you write a letter to the address, the last known address. You can place an ad in a newspaper. But does the third party actually know, and ascension is something that you need to deal with? So this expression of assent is expression of assent is by the third party. So they agree with the conferred right. So they need to express to the promissor. Thank you. Any other questions? The whole spirit of Clause 6 is that the third party who has the conferred benefit need to know of the existence of this clause, and they accept this arrangement. That is a prerequisite. Is that correct? One possibility is yes, and they agree. That is what the situation 2A. In 2B is there's reliance, but they must have accepted to exercise reliance. They were aware of this right and they've taken certain steps. So that would comply with 6.2b. If they weren't aware of the arrangement, there's no way they can receive benefit. If they've relied on that in action, yes, I agree. So in 3, subclause 3, so A and B have a contract conferring rights to C, but A and B can state in the contract they don't need C's agreement, and they can rescind the contract. When you said A and B set a draft contract conferring rights to C, so if A and B state clearly that they could rescind the contract without C's agreement, so C cannot participate even if they are aware of such a clause, but because of A and B's arrangements, they have no say in that. Yes, that is the case. If the two parties can express through the contract, they don't need the third party's agreement to rescind or vary the contract. But there's a safeguard in subclause 4. They need to notify the third party of such a clause.
That's for unilateral rescission or bilateral rescission without the consent of the third party. Or they can resort to other approaches to notify the third party of that arrangement. The two parties have the right to make that arrangement, but they have to notify the third party before they can exercise their right of rescission. So let's adjourn here. The next meeting will be held on the 16th of June, also a Monday. Well, I hope that by that time we'll be on the normal track again. So it's the 16th of June at 4:30 p.m. to 6:30 p.m. also in conference room 2A. If at the next meeting we cannot complete our scrutiny work, then the following meeting will be held on the following day, the 17th of June at 10:45 a.m. to 12:45 p.m. in Conference Room 3. So tentatively 2 more meetings. Mr. Chairman, at least the English text of the bill should refer to the statutory laws of other jurisdictions. Is my understanding correct? Mr. Wong, to a great extent, we took reference from the relevant provisions in the UK, but we also took reference from the practice in other jurisdictions. Mr. Leung, I note that last time you mentioned the precedents in UK and other jurisdictions in relation to laws and precedents. Mr. Wong and his colleagues and his team have drafted another paper, 623/01, setting out certain precedents. Today we don't have time for that. Next time we'll ask Mr. Wong to take us through certain precedents in terms of principle to see whether or not this bill has clarified the provisions on the basis of those cases, those precedents. Besides, Mr. Ronnie Tong asked 2 questions, and you responded to certain views of the deputations just now. I hope that for the first part of the next meeting on the 16th of June, we'll follow up on those issues before we continue with clause-by-clause scrutiny. Well, before the summer recess, this bill may not be able to go to the Council for resumption of second reading. So